Alright, stay with me here because what happened at 6:47 this morning, while most of America was sleeping, represents one of those inflection points that legal historians will reference for generations. Not because of the political implications, but because of the legal mechanics, the constitutional machinery that just activated in the most consequential way imaginable. 3 federal judges, unanimous decision, 8 hours from emergency filing to complete, unequivocal rejection. And the language they employed wasn't the careful, hedging prose you typically encounter in genuinely difficult appellate cases. It was absolute. Subscribe right now because what I'm about to walk you through is how the American legal system appears when every procedural exit closes simultaneously, and the countdown to trial becomes inexorable. Let me take you through the precise timeline because the speed reveals everything about the strength, or rather, the complete absence, of Trump's legal arguments. 11 p.m. last night, Trump's attorneys file an emergency application with the D.C. Circuit Court of Appeals. They're requesting that the court pause all proceedings while they pursue immunity appeals to the Supreme Court. This is a procedural tactic they have deployed successfully dozens of times throughout the past year. File emergency motions, generate procedural complexity, manufacture delays, purchase additional time, and courts being inherently deliberative institutions that treat emergency applications with appropriate gravity, typically respond with methodical care. They establish briefing schedules, they request responsive submissions from opposing counsel, they occasionally schedule oral arguments. The entire procedural sequence typically unfolds over days, sometimes weeks, because the institutional stakes are elevated and legal prudence demands thoroughness. This morning, 6:47 a.m., less than 8 hours after Trump's emergency filing reached the court, the judges respond. Not with questions, not with requests for supplemental briefing, not with a scheduling order for oral arguments, with complete, unanimous, final rejection, per curiam. That's critical legal terminology you need to understand. It means the opinion is issued by the court as a unified institutional body rather than being individually authored by a specific judge. No individual judicial name appears on the opinion. No separate concurring statements explaining particular judges' reasoning. No dissenting opinions expressing disagreement. Just the court speaking with one undivided voice. When a federal appellate court issues a per curiam opinion in under 8 hours, responding to an emergency application, they are transmitting the clearest possible signal to the entire legal community. Your arguments are not marginally weak or subject to reasonable debate. They are so thoroughly fundamentally lacking in legal merit that we do not require additional time, we do not need oral arguments, we do not even need to deliberate extensively among ourselves beyond the hours required to draft this opinion. The answer is no. It was always going to be no, and it is so obviously incontrovertibly no that we are informing you before sunrise. Now listen carefully to the opening language, because in appellate opinions, every single word carries deliberate meaning. Quote, former President Trump's alleged efforts to remain in power despite losing the 2020 election were unprecedented in our nation's history. Unprecedented. Federal courts do not deploy that word casually or for rhetorical effect. In formal legal writing, unprecedented carries specific, substantial weight. It means this situation has literally never occurred before in recorded American constitutional history. Not in 248 years. No president has engaged in this conduct. No federal court has been required to address anything remotely analogous. The opinion continues with equally definitive language. No version of presidential immunity, whether absolute or presumptive, was ever designed to shield a president from prosecution for attempting to obstruct the lawful transfer of power. No version. Not this particular legal interpretation fails to provide protection. Not under these specific factual circumstances, immunity does not apply. No version. The court is explicitly stating that no reasonable good faith construction of presidential immunity doctrine could possibly encompass what Trump allegedly did. When 3 appellate judges employ language like unprecedented and no version in a unanimous opinion issued at dawn with 0 dissent, your legal strategy has not simply encountered a setback. It has been systematically, comprehensively dismantled at every argumentative level. If you're finding this analysis valuable, hit that like button right now, because what I'm about to explain is why the Supreme Court's silence is the most significant development in this entire sequence. Trump possesses exactly one remaining procedural pathway: appeal to the Supreme Court of the United States. 6 conservative justices, 3 of them appointed by Trump himself during his presidency. Chief Justice John Roberts, who has historically demonstrated substantial concern about protecting executive branch prerogatives and maintaining the institutional credibility of the federal judiciary. Surely someone on that court would intervene. Surely someone would grant an emergency stay to preserve the procedural status quo. Surely someone would conclude that this case raises sufficiently novel, significant constitutional questions to warrant Supreme Court review before trial proceedings commence. 13 hours have now elapsed since the D.C. Circuit issued its ruling. Not one justice has issued a stay. Not one justice has requested additional briefing from the parties. Not one justice has issued any statement or order, giving even the slightest indication that they view this case as requiring immediate Supreme Court intervention. Complete institutional silence. And in the specific context of emergency applications, where time-sensitive relief is being sought, silence is not ambiguity or indecision. Silence is an answer, the most definitive answer the Supreme Court can provide without issuing a formal written opinion. We have already established the governing immunity framework in our previous ruling. The D.C. Circuit Court of Appeals correctly applied that framework to the specific facts of this case. Your alleged conduct falls entirely outside any immunity protection we recognized. We are finished with this matter. Senator Lindsey Graham, a Republican from South Carolina and one of Trump's most consistent defenders throughout 2 impeachment proceedings, stated this publicly. If the Supreme Court doesn't intervene, we could be looking at a criminally convicted Republican nominee in 2024. Think carefully about what that statement represents. A sitting United States senator from the defendant's own political party is publicly acknowledging that criminal conviction of his party's presidential frontrunner before the general election is now a realistic scenario he must discuss openly with constituents and media. Here's what happens next. Procedurally, and this is where constitutional and statutory machinery becomes truly inexorable once properly activated. The Speedy Trial Act, codified at 18 United States Code Section 361, is federal statutory law. It mandates that criminal trials must commence within 70 days once all preliminary immunity questions have been conclusively resolved and appealed. The D.C. Circuit just resolved the immunity question, unanimously, definitively, at 6:47 this morning. The 70-day statutory countdown initiates when the court's mandate formally issues. That occurs when the complete written opinion is published, which legal experts closely monitoring this litigation expect within 28 days. February 12th is the projected date based on typical D.C. Circuit publication timelines. 28 days from today, that full opinion becomes final and the mandate issues. At that moment, Special Counsel Jack Smith can invoke the Speedy Trial Act and demand immediate trial commencement under statutory authority that Judge Tanya Chutkan cannot discretionally override or delay, absent extraordinary circumstances that do not exist here. Judge Chutkan, who presides over this case in the United States District Court for the District of Columbia, previously established a trial commencement date before these immunity appeals began, consuming months of calendar time, March 4, 2026. If the Supreme Court maintains its current posture of deliberate silence, if no unforeseen procedural complications materialize, that March 4th date transitions from contingent scheduling to legally immovable reality. 70 days. That is the remaining temporal window between this present moment and Donald Trump standing in a federal criminal courtroom facing 4 felony charges related to alleged attempts to overturn the 2020 presidential election. And Trump's legal team understands with absolute clarity what awaits them when that trial commences. Drop a comment right now with your assessment, because what I'm about to describe is why the evidentiary landscape is so devastating for the defense. The prosecution's witness list: Michael Pence, Donald Trump's own vice president. The constitutional officer Trump allegedly pressured repeatedly, systematically, over multiple weeks to reject duly certified electoral votes on January 6, 2021. The man who refused despite enormous political and personal pressure. The man who will now testify under oath, subject to cross-examination, about every conversation, every pressure tactic, every attempt to convince him to violate his constitutional oath of office. Mark Meadows, Donald Trump's own White House chief of staff, present in the room for every critical meeting during the entire post-election period, aware of every strategic document, privy to every planning discussion. Federal prosecutors have reportedly applied substantial pressure to secure his complete cooperation, and sources indicate he may transition to cooperating witness status, which would be absolutely catastrophic for Trump's defense. Pat Cipollone, Donald Trump's own White House counsel, the attorney whose professional and constitutional duty required him to provide legally sound, accurate counsel to the president. The lawyer who repeatedly, explicitly in documented memoranda, told Trump that his proposed actions were illegal under federal law, who warned him directly and specifically that he could not lawfully do what he was planning to attempt. Cassidy Hutchinson, The White House aide, whose administrative position provided her access to virtually everything occurring in the West Wing, who maintained contemporaneous written notes as events unfolded, who possesses documentary records of meetings, conversations, and presidential decisions, who already provided extensive sworn testimony before the January 6th Select Committee that has been widely broadcast and is part of the public record. These are not partisan Democratic operatives with obvious political motivations to fabricate testimony against Trump. These are individuals Trump personally selected and appointed to the most sensitive, trusted positions within his presidential administration. People he granted access to classified information and executive decision-making processes, and they will all testify against him under penalty of federal perjury statutes, carrying substantial prison sentences. And the evidentiary foundation supporting their testimony is comprehensive. Text messages obtained through federal grand jury subpoenas, email communications documenting coordination and advance planning, phone records establishing contact patterns at critical temporal junctures. The January 6th video footage that has been broadcast globally and is already incorporated into the public documentary record. Trump's legal team has reviewed all of this evidence through the discovery process. They understand with precision how devastating this evidentiary compilation will be when presented systematically to a jury by experienced federal prosecutors. That understanding explains why they have invested 12 months deploying every conceivable delay tactic and procedural maneuver to prevent trial from actually occurring. Every immunity claim, every jurisdictional challenge, every procedural motion, every interlocutory appeal. The entire strategic orientation has centered on one singular objective: push the trial date beyond the November election, gambling that if Trump wins the presidency, he can utilize presidential authority to terminate federal prosecution against himself. That strategy died at 6:47 this morning when 3 federal judges unanimously rejected it, using language that forecloses any further appellate challenges on immunity grounds. Share this video right now with someone who needs to understand the legal framework, rather than political narratives. And Trump's response to this judicial rejection reveals everything about his psychological state and strategic judgment. The Truth Social posts commenced within minutes of the ruling's publication. All capital letters, personal attacks directed at Judge Chutkan, accusations of election interference and systematic judicial conspiracy, claims that Obama judges are deliberately destroying American democracy through politically motivated prosecutions. And then the specific post that triggered immediate security alerts across every federal law enforcement agency with protective responsibilities in Washington. If these witch hunts don't stop, our country will face problems the likes of which we've never seen. Analyze that language with precision. A former president of the United States, currently facing federal criminal prosecution for allegedly attempting to prevent the constitutional transfer of power, is now publicly stating that the nation will encounter unspecified problems of unprecedented magnitude if criminal prosecution continues. This is not protected political speech, subject to broad First Amendment interpretation. Federal law enforcement agencies with threat assessment responsibilities are treating this statement as a credible threat requiring operational security responses and enhanced protective measures. And here's what Trump apparently fails to comprehend about the legal implications of his compulsive social media behavior. Every single post he publishes becomes potentially admissible evidence in federal court. Every personal attack directed at Judge Chutkan. Every statement that could reasonably be construed as attempting to influence potential jurors. Every comment that could constitute witness intimidation or tampering. All of it is being systematically archived, time-stamped, authenticated, and compiled by federal prosecutors who are simultaneously building a contemporaneous obstruction of justice case. Trump cannot control his impulse to post inflammatory content on social media, and every word he publishes on those platforms strengthens the evidentiary foundation for additional federal criminal charges beyond those he already faces. Washington, D.C.'s current physical security posture reflects institutional assessments of genuine credible threat to public safety and governmental operations. United States Capitol Police have elevated operational alert protocols to the maximum classification level. Physical security barriers are being systematically erected around the federal courthouse where trial proceedings will occur. D.C. Metropolitan Police are maintaining continuous coordination with the FBI's Washington field office. Joint terrorism task forces are actively monitoring social media platforms and encrypted communications channels for indicators of planned violence or civil disturbance. This represents day 1 of a 70-day operational security countdown. FBI threat assessment teams have classified the current risk environment at the maximum possible rating. The United States Marshals Service is developing enhanced security protocols specifically for courtroom proceedings, including armed federal presence at all entry points and continuous monitoring of the courtroom gallery during trial sessions. Formal protective details have been activated for all key personnel, federal prosecutors, anticipated government witnesses, and Judge Chutkan herself. The events of January 6, 2021 provided federal law enforcement agencies with institutional lessons they will never forget. They observed Trump's rhetoric transform into kinetic violence directed against the United States Capitol. They watched D.C. Metropolitan Police officers physically beaten with improvised weapons. They witnessed windows shattered and legislative chambers violently breached by individuals who genuinely believed they were acting on legitimate presidential authority. These agencies are institutionally, operationally determined never to be caught unprepared again by underestimating the threat environment. Let me be legally precise about the specific criminal charges Trump faces, because analytical specificity matters enormously when evaluating probable trial outcomes. 4 federal felony counts. Count 1, conspiracy to defraud the United States under 18 U.S.C. 371. Count 2, conspiracy to obstruct an official proceeding under 18 U.S.C. 1512. Count 3, obstruction of an official proceeding under 18 U.S.C. 15. These are not vague political accusations concerning policy preferences or executive decision-making prerogatives. These are specific federal felonies with precisely defined statutory elements that must be proven beyond reasonable doubt through legally admissible evidence. The jury pool dynamics present their own significant factors that dramatically affect trial outcome probability. Washington, D.C. as a jurisdiction voted 92.1% for Joe Biden in the 2020 presidential election. Trump's legal team is acutely, painfully aware of this statistical reality. They have filed numerous motions seeking venue change to a jurisdiction with more politically favorable jury pool demographics. Every single motion has been denied with detailed legal reasoning explaining why venue must remain in the district where the alleged criminal conduct occurred. They will face 12 jurors selected through voir dire from Washington, D.C.'s registered voter population. Statistical probability indicates that at least 10, possibly 11 of those 12 jurors voted for Biden. Many of them watched January 6th occur in their city in real time. Some of them work in federal buildings or have family members employed by the federal government. They lived through the chaos, the fear, the sense of democratic violation in the city where they reside and work. But here's what matters more than jury pool political demographics. Prosecutors are not relying solely on jurors' partisan preferences or emotional responses to January 6th. They are relying on evidence, sworn testimony from Trump's own presidential appointees, documentary proof that cannot be reasonably disputed, video recordings that speak for themselves and require no interpretive framework. When your own vice president testifies under oath that you systematically pressured him to violate his constitutional duties, when your own White House chief of staff describes Oval Office meetings where you were explicitly repeatedly told that your planned actions constituted federal crimes, when your own White House counsel produces contemporaneous written memoranda documenting legal warnings you received and ignored, political party affiliation becomes legally irrelevant to jury deliberations. Evidence determines trial outcomes in the American criminal justice system, and the evidentiary record prosecutors have compiled in this case is extraordinarily powerful. Subscribe to this channel right now if you want continued legal analysis rather than political commentary. Turn on notifications because significant procedural developments will occur with regularity throughout this 70-day countdown period. The D.C. Circuit ruled at 6:47 a.m. with complete unanimity using language that forecloses further immunity appeals. The Supreme Court has maintained deliberate, meaningful silence for 13 hours. That silence is not ambiguity or delay. That silence represents their institutional ruling. No procedural rescue is forthcoming from the Supreme Court. No immunity claim will succeed on any further appeal. No delay tactic remains legally available under federal criminal procedure rules. No exit pathway exists. What remains is evidence presentation in a federal courtroom, witnesses testifying under oath subject to cross-examination, documentary exhibits introduced through proper evidentiary foundations and chain of custody procedures, a jury of 12 D.C. residents deliberating based on jury instructions provided by a federal judge, a verdict rendered according to the constitutional standard of proof beyond reasonable doubt. And in 70 days, we will possess empirical data about whether the American constitutional system can hold a former president criminally accountable using the identical evidentiary standards and procedural rules it applies to every other criminal defendant, regardless of wealth, power, or political position. The countdown initiated at 6:47 this morning. The clock is operating, and the machinery of constitutional criminal accountability is now fully irreversibly operational. I'll see you in the next analysis as developments continue to unfold. Because they will continue rapidly now, and you need to understand the legal and constitutional framework as it operates in real time. The procedural walls closed, the exits sealed, the countdown commenced, and American constitutional criminal law is about to answer a question that has never been empirically tested in 248 years. Can the system effectively constrain, prosecute, and potentially convict a former president who allegedly attempted to prevent the peaceful, constitutional transfer of power? 70 days. That's the remaining window until we know. Stay with this analysis. This is constitutional history unfolding in real time, and we are all witnesses.